Hi everyone, I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. In a prior episode, we talked about data breach litigation, and in particular, what was happening recently within the Fourth Circuit in the Marriott case, where the district had found that the court erred in certifying certain classes without considering the effect of a class action waiver signed by plaintiffs. Today, we're going to dive into that even a little bit more, and we're going to explore what would have happened if the plaintiffs in Marriott had assented to an arbitration agreement where class action waivers are often at play. I'm so pleased to be joined by two of my colleagues, Vassi Iliadis and Laura Penaranda, from our privacy and cybersecurity litigation practice to discuss all things arbitration and cyber. Laura, Vassi, thanks so much for joining me.
Thanks, Scott, for having us.
So, Vassi, maybe I can ask you to get us started, because arbitration has been around for a very long time. As you have reminded me and advised me over the course of years, we have arbitration clauses in a number of agreements and a number of different settings. And I think what we're seeing now is a particular focus on how arbitration and cyber come together. But before we start there, maybe you can just help the audience get up to speed. What is an arbitration clause? What is an arbitration proceeding? Why is it relevant to the privacy and cybersecurity space?
Yeah, no problem. So arbitration clauses in class action waivers are really a fixture of American contracts. They've been around for a long time. Just to put it simply, arbitration is a procedure where a dispute is submitted by agreement of parties to a neutral third party to make a binding decision on the dispute. It falls into the realm of a private dispute resolution. So instead of going to court, you're having a neutral third party, typically it's a former judge or a former attorney who is practicing in a particular area for a long time, and you agree privately to settle your dispute using that neutral third party in a private space. And I would say that companies, particularly employers, were using arbitration clauses for a very long time in their employment agreements. And over the last decade or so, companies across all industries, and in particular consumer-facing industries, have been using arbitration clauses in their consumer-facing agreements. How that relates to the privacy and data security space in particular is that a lot of companies, particularly website operators, are putting arbitration provisions in their online terms of use. And when those types of companies suffer a data security incident or a privacy issue and are faced with a dispute, oftentimes that arbitration provision within the terms of use will say that a dispute related to use of the online services or use of the company's services would be subject to arbitration. And so we are increasingly seeing not just class action litigation in the data breach space, but also arbitration demands that are being filed against companies who have decided over the years to put an arbitration clause in their consumer-facing terms.
So, Vassi, it's really interesting. All the listeners of this podcast very carefully read over every terms of use that they sign up to. Listeners of other podcasts may not be so careful. Maybe you can describe a little bit, what do those class action waivers and arbitration provisions say in those terms of use?
Yeah, so oftentimes arbitration provisions and class action waivers go hand in hand. The arbitration provision may say something like, any or all dispute or claim or cause of action you have against us, right? So the company whose online terms of service are being used relating to the use of the services will be subject to binding arbitration. And then right below that, you will get a class action waiver that often says that by entering into this agreement with the company, that you are forfeiting your right to bring a class action suit in court. And so you are both agreeing to privately arbitrate any dispute you have with the company, so outside of court, and you are affirmatively and expressly agreeing to not bring a class action lawsuit against the company.
So, Laura, maybe I can ask you, it sounds to me from what Vassi was describing a moment ago is that arbitration provisions have been quite common as part of terms of use and different types of customer-oriented agreements. But it wasn't privacy or cybersecurity that was driving the placement of those provisions, right? In other words, those arbitration provisions had been included because they were optimal for other purposes outside of cyber. So before we get into how arbitration and cyber are connected at this point and how we are seeing that play out inside of the dispute context, can you describe a little bit more about what an arbitration procedure looks like and why they have been so popular in the past?
Yeah, definitely. And so I think one of the main reasons that arbitration has been considered a favorable forum is that it provides a flexible and cost-effective option for these companies. And there's a few differences compared to traditional litigation that kind of increase that flexibility and increase that cost savings. And so one of them would be streamlined discovery, which can be, as I'm sure a lot of listeners know, one of the costliest aspects of litigation. It can take months, it can take years. And so in the arbitration context, it'll often be, expedited or limited. And then arbitration also tends to limit motion practice and just gives parties a lot more opportunity to kind of like craft how the proceeding will take place, whether it's deadlines, if the arbitration is on the papers, if it's a virtual hearing. There's just a lot more options for companies.
The other thing I would say, Scott, in addition to the good points that Laura made, is that it's an overall faster and more efficient process. So it is favorable and has been considered to be favorable to respondents, companies who put the arbitration provisions in their agreements. And I think there are a couple other benefits that are worth considering when you're deciding whether to put an arbitration provision in your terms of use. The first is there are a lot of skilled and sophisticated arbitrators to choose from. The parties can play an active role in selecting who their third party is going to be. That's very different than being in court where a judge is assigned. And in certain courts, you may have a more sophisticated bench of judges than others. And when I say sophisticated, I'm talking about judges who may have experience hearing disputes that involve technology, issues of cybersecurity, issues of data protection. In arbitration, the parties can work together to select an arbitrator who has that exact experience, including retired judges. I think it overall can be more flexible and collaborative than being in court, right? If there's a dispute, you can simply email the case manager and the arbitrator and spend 30 minutes talking about it live when it works for everyone's schedules. Whereas in court, you have to go through extensive and costly motion practice to get a dispute heard. And the other benefit in arbitration is deciding who your arbitration provider is going to be. So that's the company who is actually going to administer the arbitration. Some companies have specific rules around discovery and motion practice. And while there are a lot of similarities between the arbitration providers, there can be key differences. So it's important to look at who the arbitration provider is and who you want to work with to actually administer the arbitration. So that all goes to the level of flexibility that Laura flagged earlier for why a lot of companies, especially consumer-facing companies who might face these kinds of cyber disputes, would be inclined to put an arbitration provision in their terms of service.
So that means that there's a lot of benefits to being able to use, arbitration provisions, which I totally can see why they've become so popular in the past, including that they are, as you said earlier, paired with class action waivers. I think, a number of organizations are concerned with being hit with class action litigation following a data breach, which is a pattern and practice that has become kind of widespread and prevalent. But now I keep hearing the term mass arbitration, which makes me think maybe that the arbitration landscape has shifted. Vassi, what is mass arbitration? And from your perspective, how has the arbitration practice changed over the past few years?
Yeah, that's a really good question and a really important point. So to take a step back, as you noted, over the years in data breach suits, a lot of companies have decided once they're faced with a data breach class action in court to try to move to compel arbitration of those claims individually because of the arbitration provision in the online terms of service. And a lot of companies, including clients that we've represented, have been successful in doing that. In other words, getting data breach class actions out of court and into arbitration. But in recent years, that mass arbitration trend that you mentioned has been a real challenge for a lot of our clients and for a lot of companies facing these kinds of issues and disputes. What mass arbitration is basically it's an emerging trend where thousands of claimants are filing individual arbitration demands simultaneously. So essentially, what the plaintiffs' bar has done is engineered a private enforcement regime that uses similarly situated plaintiffs that could have been part of a class action to pursue claims that were previously thought to be non-viable due to arbitration clauses and class action waivers. So what the plaintiffs' bar is doing is saying to the companies, okay, you want it your way, you have an arbitration provision in your agreement, don't worry, we won't bring a class action, but instead we're going to file 100,000 arbitration demands on behalf of 100,000 claimants, and you're going to have to fight those arbitration demands. And so it's really become a sort of Damocles for a lot of companies because they've used it as a protective mechanism at first, given all of the benefits and flexibility that we've discussed, and are now facing mass arbitration demands instead of class actions, which can be incredibly unyieldy and create a ton of exposure, more so than even a class action lawsuit that's filed in court. And so that's what we've been seeing as of late, Scott.
So it sounds like it's just another backdoor way of getting to a class action, which was the very thing that the companies intended to avoid by including the class action waiver and the arbitration. Is that a fair way of thinking about it?
It's almost worse than a class action because the whole purpose of a class action is to be able to litigate and adjudicate these disputes in a way that makes sense, in a way that is reasonable for the company and reasonable for the court. And now companies are facing hundreds of thousands of claims individually and are facing them simultaneously. So it is essentially taking the class action mechanism and putting it on its head and making companies face this in individual claims out of court.
What are the economics of that, right? Because each one of those individual arbitration proceedings has a price tag, right? Someone has to pay for the arbitrators. That's not a court-appointed position, not funded by the taxpayers. There is a whole kind of process that needs to be built out. Is that something that the company is responsible for? Is that a price tag that hits the plaintiff lawyer bringing the case? How does that work?
Laura, you want to take this one?
Yeah, that's a great question. And I think that's one of the main issues that mass arbitration is bringing for these companies, because starting with filing fees alone, if a respondent is filing and the filing fee is $2,000 and there are 5,000 arbitration demands, the initial filing fees alone would amount to $10 million. And that doesn't even account for the cost of administering the arbitration proceeding beyond the filing phase. And so plaintiffs' firms are, trying to use this to leverage and push their settlement negotiations by, driving up these huge fees.
Laura, I mean, that's really interesting to see how the economics of these arbitration provisions work nowadays. That combined with the issue that Vassi was describing around mass arbitration and really kind of resulting in a costlier version of class action litigation, does that mean that companies are no longer looking to leverage arbitration? And if they do, is there any way of trying to avoid these risks?
Yeah, I think companies need to be very thoughtful, and if they have a risk of mass arbitration, they need to take a really close look at their current arbitration agreement and kind of weigh the cost and benefits of implementing potential revisions to try to address some of the mass arbitration issues that we're seeing. And so, one way they can do that is potentially changing arbitration providers. And like Vassi mentioned, these providers have different rules in place, but as mass arbitrations are heating up, these providers are dealing with mass arbitration in different ways and on different timelines. So some have released supplementary rules for instances where there are simultaneous demands that beyond a certain threshold, maybe 20, maybe 25 of all the same claims brought by the same counsel on, a variety of named plaintiffs. But that is not the case across all providers. And then, some of these providers have also seen the fee issue and so have restructured the fees to account for mass arbitrations. But they're all moving at different paces. And so it's important to kind of stay up to date and assess what these providers are doing to address mass arbitration.
Vassi, from your perspective, is there a clear approach that organizations should take nowadays with respect to these arbitration provisions?
There isn't a clear approach. I think it really comes down to the industry the company is in, their overall appetite for risk. I have some clients who've taken out arbitration provisions altogether, and they would rather face the risk of class action suits in court rather than potentially be subject to mass arbitration. And I have other clients who decided that they wanted to maintain their arbitration provisions because the benefits outweighed the costs, and instead are attempting to make revisions to their agreement along the lines of Laura suggested. Some clients are exploring adding, for example, mass action waivers, which would, tell the parties that your dispute is subject to arbitration, but you can't bring a mass action, right? So not just a class action waiver, but a mass action or mass arbitration waiver. Some are exploring, potentially putting bellwether provisions in their arbitration agreements so that if you are going to bring a mass arbitration, you're going to agree to batch out those claims, let's say, 10 at a time. So you can't suddenly bring 50,000 claims tomorrow. The problem is, Scott, is that there isn't a ton of clarity on the enforceability of these kinds of new provisions and revisions to an arbitration agreement. And I think that we're still in the initial phases of testing the limits of these kinds of provisions in the courts. And ultimately, I think it's going to take a few years for us to see a clear path in how arbitration provisions, especially in online consumer-facing terms of use, should be written.
Pause on that one for a second, because that actually sounds very familiar and similar to the issues that we were discussing with Allison Holt-Ryan and Adam Cook on a prior podcast. And I think both of them had made the point that if you think of the many years of case law that have been developed on a number of areas of topics, privacy and cybersecurity wouldn't be on that list, right? In other words, really start at the very beginning of establishing what common law looks like and how to take core legal principles and apply it to something as complicated as privacy and cybersecurity. And what I hear you saying is actually the same is true with arbitration. Arbitration has been around for some time. These provisions that have been included for non-privacy reasons have been quite popular, and thus been an area that presumably folks had or intentionally used because they addressed other non-privacy issues. But what is unique and what is new and what is an area that I think is forcing organizations to perhaps rethink or reconfirm their approach to arbitration is that privacy and cybersecurity component. Does that sound right to you?
Yeah, that's exactly right. I think you'll even find that some arbitration provisions will expressly include now disputes related to privacy and cybersecurity, whereas before some arbitration provisions were left pretty ambiguous or high level, but still all encompassing, right? Any and all dispute against the company. And some of our clients are deciding to get even more granular and say that if you have a dispute related to your data, your personal information, or the security of your personal information, then that dispute will be subject to arbitration. So it's becoming even more granular. And what's been really interesting to see is the number of arbitrators who have this exact subspecialty and experience. These are former judges, retired judges, or former lawyers who over the years have developed this specialty, especially over the last decade, and are able to parse these issues and understand the disputes. And that's even more interesting in the arbitration context, because historically, as we talked about, these really weren't going to arbitration, and now they very much are, either because of the mass arbitration demand, because companies are trying to compel arbitration of claims that originally filed in court due to the provisions in the online terms of service.
And maybe that was really emphasized in the Fourth Circuit Marriott decision, right? Whereas the arbitration was one of the set of issues, as I understand it from that court, that indicated that that needed to be considered kind of prior to the class certification stage. So that would be maybe one of probably many areas that are really TBD at the moment around how arbitration clauses will be interpreted by courts and how they may or may not be enforceable when courts are enforcing those provisions and pushing class cybersecurity oriented litigation either into class action litigation or into mass arbitrations as you're describing.
Yeah, that's exactly right. And the interesting point in Marriott is that the named plaintiffs had agreed to these class action waivers. And that was something that the Fourth Circuit said that the district court should have considered prior to certifying the classes that were certified. And I think where we're seeing class action waivers be put hand in hand with arbitration provisions, it's an interesting thought exercise for companies on how much you want to leverage class action waiver and capitalize on that class action waiver and the risks of capitalizing on the class action waiver in light of what we're seeing today. There's no right answer, but I think it's important for our clients and for companies who are consumer-facing companies, especially website operators, to give special thought to how they're drafting their arbitration provisions, if they decided to include arbitration provisions, and how users of their websites and users of company services are actually assenting to those arbitration provisions. That's another critical component that we didn't touch on very much, but the key is to make sure that the way that you've presented your terms of use is reasonably conspicuous enough for what the courts say is a reasonably prudent internet user. Right. And so that can be a whole other topic for another day, but it's something to keep your eye on when you're considering not only revisions to your arbitration provision, but how your arbitration provision is being presented to consumers.
Vassi, I'm going to have you back on a future podcast for you to be able to describe where courts think terms of use should live, where courts think privacy notices should live, and whether individuals should be clicking through them, whether it's appropriate just to leave them at the bottom as part of a banner. Could they be hidden 10 pages in and still enforceable? All sorts of great questions. Laura, maybe one question for you is you're both describing that this trend is happening, and thus there may be some of our listeners who are thinking about this and saying, hey, this is a real world issue for me. Any thoughts on how companies are trying to address these mass arbitration demands currently?
Yeah, so similar to how companies can mitigate risks, like even if they don't have provisions currently in place in their arbitration agreements, they can try to leverage some of their existing provisions if they have a pre-dispute notice provision to try to meet with the claimants before something actually gets to arbitration. And they might have a provision that requires meeting and conferring individually to try to, slow down the mass arbitration process. And then if they are in a situation where they've received a mass amount of claims, meeting and conferring with plaintiff's counsel and trying to negotiate and create processes and efficiencies that call back to some of why companies prefer arbitration. And so parties can agree to have the same arbitrator oversee a number of proceedings. And so, as we've talked about, arbitrator selection can help parties get a really sophisticated neutral. And so it might make sense to have, someone with a technical background handle multiple cases in a batch rather than having different arbitrators of different varying levels of familiarity with key issues for these companies. And then parties can also share discovery across identical demands if they are arbitrating multiple claims at the same time, as long as it's not a plaintiff-specific discovery. And that, again, kind of goes back to one of the key benefits of arbitration in the first place, to lessen the discovery burden and make the process more efficient.
Great. Well, maybe I can kind of tie up the episode today with asking each of you maybe one final question. As I have asked guests in the past to maybe take off your hat as being a Hogan Lovells lawyer and pretend for a moment that you are in-house counsel, in-house litigation counsel in this case, and you're advising your business who also has significant data-related assets that if they were compromised was likely to result in litigation. So your business comes to you, Vassi and Laura, and says, should we be including arbitration provisions in our terms of use for our website? I'm going to give you three choices. You can say, heck yes, use caution, heck no.
It depends. So I think I would say use caution and take the tips that we've covered today into consideration when thinking about what that arbitration provision should look like.
All right. So if I have there's really only two options, right? Arbitration or class action, or mass arbitration now and class action. And of those two, it sounds like it's a case-by-case, risk tolerance by risk tolerance analysis from your perspective, Vassi.
I think that's right.
All right, Laura, I'm going to give you the same one. Heck yes, heck no, or use caution.
I have to echo Vassi and just say it depends, use caution.
Got it. All right. Well, thank you both, Vassi and Laura, for joining me on today's episode. Really enjoyed the conversation, and hopefully we'll have you back on a future episode. With that, I'm Scott Loughlin. This is the Data Chronicles, and those are your data points.